Good afternoon, everybody. My name's Edward Denehan, and I'm welcoming you to the second in a series of three webinars that I've put together concerning the determination of leases. Today's webinar concerns determination of leases by forfeiture, a means that's well known to all of us, but it doesn't shy away from being revisited, particularly at this current time. The form of the webinar for those who are attending for the first time is as follows. It will last an hour. I try hard to keep it to an hour. I speak to the three papers that I prepared for today, which we'll look at in a second, but I won't speak to everything that I've reduced to writing. The delegates will be sent the materials after the webinar, or they can download them. I can't remember which way around it is, or both. So it's not necessary to make any notes unless you want to. You'll have my full notes after the webinar. There won't be an opportunity during the webinar to ask questions or at the end of it. I find that doesn't really work very well due to my lack of tech knowledge. But what I'm happy to do is to answer, if I can, any questions that a delegate might have. If the question is just asked in the form of an email to me, I will respond to the email as soon as I can. My email address is on our website and at the bottom of the materials when you get them. And I ask that the questions be of a general nature rather than a specific case that you have, for reasons that I hope are obvious. So if we move on, you'll see that the three papers that I'm going to speak to today are restrictions on forfeiture, means and effect of forfeiture, and waiver of forfeiture. Forfeiture is a large and complicated subject, and it would be impossible in an hour to deal with each and every element of it, but I've chosen these because they occurred to me to be topics of interest and topics where I often see doubt, if not mistakes. The first of the papers, restrictions on forfeiture, I set out with the intention of trying to provide a definitive list of all the restrictions that might impact upon a landlord seeking to determine a lease by forfeiture. And in my usual way, I bit off rather more than I can chew, because there's an enormous amount of restrictions that do have that effect. I've even been driven to prepare for the materials that support this paper a table of contents, which you'll see on the screen now, and I've identified 5 particular areas where there are restrictions imposed on landlords seeking to forfeit leases. 1 through 15, they're on the screen as I speak. It's going to be a temporal impossibility to speak to each of these in to any degree today, so I've cherry-picked in order to fill the 20 minutes, 25 minutes or so that I've got to deal with restrictions, and I hope that they're of interest. I'm not going to warrant that everything that I've identified in this paper is the totality of the restrictions that impact, but I get comfort from thinking and believing that if there's a restriction that I haven't mentioned, then it's going to be in a very rare and very obscure case, which would probably demand a special research in any event. But as you see, there are 15 topics there. What I'm going to do is I'm going to speak to the very new restrictions imposed to deal with the impact of the coronavirus pandemic. And then I'm going to have a brief mention of restrictions imposed by the Commonhold and Leasehold Reform Act 2002 and the Housing Act 1996, because they pop up in practice quite a lot. And if I've got a little bit of time, if I go faster than I anticipate, I might just touch upon 1 or 2 of the other restrictions. I make it clear in the notes whether the restrictions apply to residential or commercial or both premises. So you'll have that definitive statement in the context of each of the restrictions that I identify. So I'm going to start then with the restrictions on forfeiture imposed by the Commercial Rent (Coronavirus) Act 2022, save for paragraph 1 of Schedule 3 in section 27. So far as section 27 relates to that paragraph, the 2020 Act came into force on the 24th of March 2022. I don't think I've ever been as topical as I am with this. And you'll no doubt have heard that this act introduces compulsory arbitration in respect of rents and so on and so forth. That's not what I'm going to bore you with today. I'm sticking to the brief, and the brief is restrictions on forfeiture. So it's forfeiture that, in the context of the 2022 Act, that I am going to address. The starting point is very straightforward. Schedule 2 to the 2022 Act contains provisions preventing a landlord who is owed a protected rent debt from inter alia enforcing a right of re-entry or forfeiture. I say inter alia because there are other restrictions in there too, but I repeat, I'm simply concerned with forfeiture. The route through the provisions in the Act and Schedule 2 in the context of forfeiture is not straightforward because, certainly as far as I'm concerned, introduces concepts and definitions which are entirely alien in the sense that I've never come across them before, and I doubt that anybody else has. It must have been fun for the draftsman coming up with expressions to describe what it is, and already we see one on the screen: protected rent debt. But doing the best I can, let's get into it, and we'll start with some definitions. And the first one is a protected rent debt. And that is a debt under a business tenancy. So we're here concerned simply with business tenancies, consisting of unpaid protected rent, section 2.1. And rent is given a very broad definition. I've set it out on the screen. It's the amount payable for the use and occupation of the premises, what one might call rent in the usual sense, but also service charges, which is normally distinguished from rent, properly so called, and interest on unpaid amounts of rent or service charges. So those three elements can all be rent for the purposes of the 2022 Act. Business tenancy means a tenancy to which Part 2 of the 54 Act applies. We all know that that's protection for, or certain sections of that are protection for tenants who occupy premises for the purposes of a business carried on by them or for those purposes and other purposes. So it's limited to business tenancies that would fall within Part 2 of the 54 Act. Protected rent is rent due under a business tenancy where one, the tenancy was adversely affected by coronavirus, and two, the rent is attributable to a period of occupation for the tenant or for a period within the protected period applying to the tenancy. We'll come on to see what those definitions are now. The main element, I suggest, is the concept of adversely affected by coronavirus. A business tenancy will be adversely affected by coronavirus for these purposes if the whole or part of the business carried on by the tenant at or from the premises comprising the tenancy, or the whole of the premises was of a description subject to a closure requirement. So we see there that the closure requirement might impact on the use of the premises as a matter of physicality. You've got to shut the business, shut the office, shut the shop, whatever it might be, shut the factory, or if it impacts on the business. So you can't carry on the business of X, Y, and Z, but you could carry on the business of A, B, and C. A, B, and C will not be adversely affected by the coronavirus. So it impacts on premises and on business. A closure requirement is a requirement imposed by coronavirus regulations which is expressed as an obligation to close businesses or parts of a business of a specified description, or to close premises or part of premises of a specified description. That makes good and certainly emphasizes the point I made in relation to the previous slide. The relevant period means a period on or after 2 p.m. on the 21st of March 2020. As far as I'm concerned, March 2020 was the beginning of the lockdown, if you will. Mine was the 18th of March, but clearly that's what the where that date comes from. And it ends on or before just before noon on the 18th of July 2021 for England, and 6 a.m. on the 7th of August 2021 for Welsh businesses. So that's the protected period. The protected period in relation to business tenancy adversely affected is the period beginning on the 21st of March, as I say, and ending on those days. Now, specific coronavirus restrictions is a restriction or requirement other than a closure requirement imposed by coronavirus regulations which regulated any aspect of the way a business or part of a business or any specified description of any specified description was to be carried on, or the way the premises or any part of the premises of a specified description were to be used. This doesn't include a requirement that you put up notices saying wear masks, keep 2 meters apart. So you can't drag oneself into a coronavirus restriction within the context of Schedule 2 merely because one had to put up a sign. The end of the protected period is defined in section 5.2, and the relevant day is the last day on which, or part of which, the whole or part of the business premises carried on by the tenant at or from the premises, or the whole or part of the business was subject to a closure requirement or a specific coronavirus restriction. Now, those are the definitions. I'm sorry, they're a little bit blurred, but in one's mind, but as I say, I've set them out in full in the note. They bring us to paragraph 5 of Schedule 2 to the 2022 Act. And this is where the restriction is to be found. And paragraph 5 says that the landlord may not, during the moratorium period for the protected debt, enforce by action or otherwise a right of re-entry or forfeiture for non-payment of the debt. The number of points arise from that is that the well-used formula by action or otherwise makes it clear that forfeiture by physical re-entry, which we'll look at shortly, or by the issue and service of possession proceedings are both prohibited by this provision. And it's also clear that the right of re-entry is only prohibited for the purposes of if the lease is to be forfeited for non-payment of the debt. That's the protected rent. If the tenant is otherwise in breach of covenant, then the landlord is not prohibited by these statutory provisions from enforcing the right of re-entry in such means as is available to the landlord under the law, something that we'll look at in a subsequent paper. The moratorium period is defined in section 23.2. I'm now going back to the body of the Act, and I've set it out in full on the screen, and it will be repeated obviously in the notes. It's the period beginning on the day on which this Act was passed, 24th of March of last month, and ending where the matter of relief from payment of the protected debt is not referred to arbitration within the period of 6 months beginning with that day, with the last day of that period, or whether the matter is referred to arbitration with the day on which the arbitration concludes. So if the tenant wants to kick the risk of being forfeited on the grounds of non-payment of rent then the tenant should elect for the arbitration, which is being facilitated by other provisions in the 2022 Act. Interestingly and helpfully, that it's made clear by paragraph 5.2 that no conduct on behalf of the landlord during the moratorium period, other than giving expressed waiver in writing, is regarded as waiving a right of re-entry or forfeiture under the business tenancy for non-payment of the debt. The final paper that I'm going to speak to this afternoon is concerned with waiver, and we'll see how waiver can arise in a forfeiture context. But this makes it perfectly clear that nothing the landlord does during the moratorium period waives the right unless there's an express waiver in writing, which I suggest is probably unlikely. I can't think of a situation where the landlord might give such waiver in writing. You'll remember that under Part 2 of the Landlord and Tenant Act 1954, a landlord can oppose an application for a new tenancy on various grounds, A through to G. One of the grounds is that in paragraph B of section 30, subsection 1 of the 54 Act, the landlord can oppose an application by a tenant for a new tenancy if there has been a persistent delay in paying the rent which has become due, and the court is of the view that it ought not to make an order for a new tenancy. Well, for the purposes of deciding whether the landlord makes out its case under 31B of the 54 Act, a failure to pay the rent during the moratorium period is to be disregarded. So the tenant is not burdened by the legacy, if you will, on a renewal sometime after the moratorium period, or certainly after the restrictions have been lifted. The landlord can't point to the failure to pay rent during the moratorium period as material to support a ground of opposition under 31B. The Coronavirus Act 2020, which contained provisions about rent, that ceased to apply on the 25th of March 2022, both in England and Wales. So all that has fallen away, and the 2022 Act, which now impacts on landlords and tenants in the context of the coronavirus crisis, if it still is a crisis, which some of us of an age believe it is. So that's the restriction that I've focused on primarily today. But I wanted to mention, as I said I would, the 2002 Act. Section 167 of that Act imposes substantial restrictions on forfeiture of long leases of dwellings in relation to non-payment of rent, service charges, or administration charges, or a combination of these three, unless the amount exceeds the prescribed sum or consists of or includes an amount which has been unpaid for more than the prescribed period. The sum is £350 and the period is 3 years, so that's not too burdensome. But I draw your attention also to section 166 of the 2002 Act, which requires landlords of tenants of long leases of dwellings to give notice to the tenants of their liability to pay rent, notwithstanding that under the general law, a landlord doesn't have to demand rent unless there's some provision in the lease or tenancy agreement that so provides. But under the general law, a landlord doesn't have to issue a demand. But 166, in the context of such tenancies of such premises, requires a landlord to do so. And unless until the landlord has done that, the liability to pay the rent doesn't arise. So one's got to look at 166 of the 2002 Act and 167 in tandem to get a full picture of how they can operate to restrict the right to forfeiture. And it's certainly 166 is a requirement that has been overlooked by some landlords in my professional experience. Perhaps more common is the restriction more common in the sense that it arises more frequently, is that contained in 168 of the 2002 Act, which prohibits the service of a Section 146 notice in relation to, again, a long lease of a dwelling, unless Section 1682 is satisfied. Section 1682 of the 2002 Act is satisfied if it's been finally determined on an application under 1684 that a breach of covenant has occurred, or the tenant has admitted the breach, or the court or any proceedings or any arbitrate tribunal has finally determined that a breach has occurred. So what that means is before the landlord, in respect of premises let on a long lease that are a dwelling, before he can or she can serve a Section 146 notice, they must establish by one of those three means that there has been a breach. So if you like, it's it is a condition precedent to the service of the Section 146 notice in those circumstances that breach be established. The most common way that is done is listed in number 1 in brackets. It's been finally determined on an application under Section 1684. Section 1684 of the 2002 Act allows a landlord of such a tenant to apply to, in England, the first tier tribunal, it's still called the Leasehold Valuation Tribunal in Wales, can apply to that tribunal for a determination. So one has if you like, a mini trial before the FTT to establish whether the breach has occurred or not. I say a mini trial, it's the burden of proof and the standard of proof is exactly the same as if it was being decided in the county court or the high court. The only difference is that if the landlord does establish that there's been a breach, the tenant is not immediately at risk of forfeiture, because the landlord then has to serve a Section 146 notice. And my recollection, I've set it out in the rules, is that they've got to wait 14 days after the determination before a Section 146 notice can be served. And as we know, in a Section 146 notice, certainly in respect of breaches that can be remedied, the landlord has got to give the tenant a reasonable time to remedy the breach. So it's I've seen this procedure being criticised because it said it exposes tenants to 2 lots of proceedings, only rather than just one. But any sensible tenant, if they fail in front of the FTT, or put it more accurately, if the landlord succeeds in establishing a breach, then the tenant will remedy the breach, and that will be the end of it, and the risk of forfeiture will fall away. In respect of the other, one more in this one. Just said that. Section 81 of the Housing Act 1996, 168 of the 2002 Act, as I say, prevents a landlord serving a Section 146 notice unless there's been a determination that there's been a breach. That doesn't apply to arrears of service charges or administration charges. And you'll remember that prima facie, a landlord doesn't have to serve a Section 146 notice if his claim is based upon arrears of rent. The reason why 168 doesn't deal with the service charges or administration charges is that they have their own jurisdiction, as it were, which is provided by Section 81 of the 1996 Act. There's a lot of overlap between Section 81 of the 1996 Act and the 2002 Act in this regard. But as I say, service charges and administration charges have their own statutory provisions, and they're found in Section 81 of the 1996 Act. The concepts that I've mentioned in the context of the 2002 Act and the 1996 Act, namely long leases, dwelling houses, and so on and so forth, have precise meanings buried away in the Housing Act 1985 and so on and so forth. I set out all the tedious details in the notes. So that's one of the reasons why the notes are so long, that I've set out the detail of that chapter and verse. In respect of the other restrictions that I've identified in the paper, some one needn't worry too much about, hopefully, thankfully. For example, the Landlord and Tenant War Damages Act, War Damage Act 1939, it's still on the statute books and could apply. But I do head up that under the Leasehold Reform Act and the Leasehold Reform Housing and Urban Development Act 1993, there are restrictions on forfeiture when a tenant has made a claim under those acts to have the freehold or an extended lease. I've recently been involved in a case under the 67 Act, that's the Leasehold Reform Act, where the tenant was in substantial breach of covenant in a large house on one of the grand estates in central London, using it for immoral purposes, the detail of which I won't go into, but they're all online if you look closely enough. The estate commenced possession proceedings against the tenants three odd years ago. He's a slippery character, and it's been bogged down in procedural mishmash since then. And then in the last 6 months, he's made a claim under the 1967 Act to have the freehold of the house, entitled to do, and that really has put a stop on the forfeiture action. In order to succeed, the tenant will have to, the landlord would have to show that the application was made in bad faith. So in these enfranchisement cases, there's restrictions. The details are all in the paper. Right, I think we've said enough, or I've said enough about restrictions, and I'm now going to move on to the means and effect of forfeiture. What I mean by that is, one, how do you forfeit? And two, what's the effect of it? And I'll start by making an obvious point, but it's worth making, I believe, that it's a matter for the landlord whether he or she forfeits a lease or not, if the circumstances in which forfeiture arises exist. The landlord is not obliged to exercise the proviso for re-entry in the event that there is a tenant's breach of covenant, and there might be compelling commercial and or estate management reasons why the landlord will not wish to bring the lease to an end, but rather will simply pursue the tenant for the other remedies that are available to a landlord when a tenant is in breach of covenant. Suing for the debt if it's rent, for damages if the landlord suffered loss and damage, an injunction to prevent continuing or future breaches of covenant, an order for specific performance to force the tenant to comply with an obligation, repair, for example. Second general point I wish to make by way of preface is that the landlord must have an intention to forfeit. It must be a conscious decision by the landlord that that's what they want to happen. And that intention must be manifest by some unequivocal and positive act on the part of the landlord. Landlord, you really can't forfeit by mistake unless objectively anybody assessing the act of the landlord could only conclude that the landlord's act were consistent with an intention rather than a mistake. Once the landlord has manifested that an intention by taking an act of forfeiture, which we'll talk about in a minute, it can't be retracted. So you can't change your mind halfway through. So if a landlord's forfeiting a lease and then there's to get VP in order to relet the premises at an increased rent, and then there's some crises, be a virus or a European war or whatever it might be, the landlord can't reel it back and say, well, I'll stick with the tenant because nobody's taking new premises at the moment. So those are comments by way of preface to this paper. There are two means by which a forfeiture may be affected. And one is by physically re-entering the demised premises, sometimes called peaceably re-entry. And the second is by legal proceedings in which possession of the demised premises is claimed, which is claimed. I'll look at each in turn. Physical re-entry is simply requires the landlord by himself or herself or a duly authorized agent to physically re-enter the demise premises with the intention of forfeiting. 90% of proviso for re-entries provide that the landlord can enter part of the demise premises in the name of the whole, and that will be a sufficient re-entry to forfeit the lease of the whole. The landlord, as I say, must physically re-enter with that intention to forfeit. If the landlord enters upon the premises for some other purposes, in the exercise of a right to inspect the premises, that will not be an act of forfeiture. In the Relvoc Properties case, which I refer to on the screen, and it's dealt with in the notes at some length, the tenant just did a midnight flit. The landlord went, it was a hairdresser's, the premises, the landlord went in to secure the premises because there were equipment left in the premises. And the original tenants, who were then being pursued by the landlord for rent under their direct covenant, said, Yabu sucks, the landlord re-entered and the lease came to an end there. But the landlord had seemingly very little difficulty in persuading the court that he had entered simply to secure the premises and had not sought to forfeit the lease. I've called this the mechanics of physical re-entry. How do you affect it? Depends upon the nature of the demise premises. If it's a building, dare I say it, just change the locks. That will be sufficient. If it's open land, some other means of making it clear there's been an entry, signs on posts stuck into the ground. There's an Australian case where the landlord erected a chain around some open land, and so on and so forth. Whatever the acts the landlord relies upon to forfeit a lease, they must be unequivocal, and that's a crucial ingredient. I advised some clients recently who were seeking to forfeit slightly unusual premises on an island in the middle of the River Thames, that they should just get a well-respected, if there is such a thing, firm of bailiffs to do it, because they're used to the mechanics, as it were, of forfeiting. Constructive re-entry, what I mean by that is that the landlord doesn't physically re-enter the premises and take possession of them in a physical sense, or occupy them in a physical sense, but there can be constructive re-entry if the landlord lets into possession and by a third party as a new tenant. The third party might be an existing subtenant of the landlord, provided there is a new lease. Simply asking the subtenant to pay the rent under its subtenancy to the landlord will not be constructive re-entry for these purposes. As I have touched upon, which you haven't read yet, but in the first paper, I identify some legal restrictions on forfeiting by physically re-entry. An example, perhaps a prime example, is Section 2 of the Protection from Eviction Act 1977. That says, in effect, that re-entry, physical re-entry, cannot be lawfully exercised otherwise than proceedings. Sorry, forfeiture cannot be otherwise than proceedings in court where the premises are let as a dwelling and there is some person lawfully residing in the premises. So if it's a dwelling house and there's somebody lawfully residing there, you can't physically re-enter. You've got to forfeit by the other means we'll speak of in a minute. Note that it's got to be premises let as a dwelling, and there's got to be somebody lawfully residing there. It doesn't have to be the tenant, as long as there's somebody residing there and is lawful. So if there's a flat, for example, which is a dwelling on a long lease, but there's nobody living there, then the landlord can physically re-enter the premises if there's a forfeiture event available to the landlord. I've done a few cases like that over the years, usually when there's been a marital breakdown and both parties flee and don't pay service charges and so on and so forth. If there's nobody residing, the landlord can enter the premises, but clearly caution is needed when dealing with dwelling houses because of the criminal consequences of not forfeiting in the correct way. This Patel case decided, little to my surprise, that let as a dwelling in section 2 means let wholly or partly as a dwelling. So if you've got a dwelling, if you've got a demise of a shop with a flat above, I would have said that that's not let as a dwelling, it's let as a dwelling and as a shop. But in the Patel case, the Court of Appeal held that section 2 of the 77 Act is caught by that, and I can see perhaps good policy reason for that. Section 6 of the Criminal Law Act creates an offence to use or threaten violence to secure entry into premises if there's somebody physically on the premises at the time who is opposed to the entry of which violence is threatened, and that person using or threatening violence knows this to be the case. Pause there. That's not limited to landlord and tenant. It's simply somebody who's physically on the premises. Their status there may not be legitimate in any sophisticated way, but you can't threaten violence to throw people off land. And this is not limited to dwelling houses or indeed anything else. And it's offence, it's a criminal offence, but it doesn't invalidate the forfeiture, funnily enough. It simply creates a criminal offence. Section 2 of the Protection from Eviction Act, which we just looked at, that makes a forfeiture by physical re-entry unlawful, because you can only lawfully forfeit by court proceedings. There's an old case which I refer to in the notes where the landlord entered the premises, pushed the husband tenant out, and removed the wife and her baby from the premises in a chair because she wouldn't leave the chair. But I wouldn't suggest that these days. The second means of forfeiting is by the issue and service of a claim form claiming possession of the demise premises against the tenant, and that's a sufficient indication of the landlord's intention to forfeit the lease. And there's a bag of authorities, including the two I mentioned, to support that proposition. The Canis property case, decided at the beginning of the 70s, supports the proposition that it is the service of the claim form, the writ, the originating summons back in the day before the CPR. It's the service of the claim form that affects the forfeiture. It's not the issue of it, it's the service of the claim form on the tenant. And if the tenant can't be found because he or she's on a midnight flit or just avoiding it, then there are other means by which one can effect service. Most obvious one would be to obtain an order for a substituted service. So it's the service of proceedings claiming possession on the tenant that affects the re-entry. To be effective, the service must be on the tenant for the time being. So, for example, if there's the breach of a covenant against assigning the lease, an assignment in breach of that covenant doesn't render the assignment void. The assignment is effective, and therefore the assignee is the tenant for the time being, and it's that person who should be the defendant of the proceedings and on whom the proceedings are served. Watch out for the registration gap. You'll recall that an assignment might take place on a Monday, but the assignee might not be registered as a proprietor of the leasehold estate for some time after. The better view seems to be that you've got to sign, in the case of a registered lease, one would have to serve the proceedings on the proprietor, the registered proprietor, and that might well be, in the example that we've given, the assignor who's in breach of covenant rather than the assignee. Make a couple of miscellaneous points. The proceedings for possession can include claims for additional remedies, such as damages, but be wary of inconsistent claims which may render the proceedings ineffective. A claim for an injunction, in addition to a claim for possession, is an inconsistent claim, and therefore the court would treat the service of the proceedings as being equivocal, because the tenant wouldn't know and the objective bystander wouldn't know whether the landlord had an intention to forfeit or an intention to enforce the tenant's covenants in the lease. An intention to enforce the covenants in the lease is only consistent with the the lease continuing. So it's equivocal, and those proceedings will not be effective to bring the lease to an end. A claim for possession of demised premises on the ground that the lease has been forfeit is a possession claim within the meaning of CPR 55, and therefore the procedure prescribed by that rule must be followed. Right, now that's the means of forfeiture, or pretty straightforward, I suggest. What's the effect of forfeiture? I'll deal first with physical re-entry. That's, again, straightforward, I would suggest. The lease comes to an end immediately upon the re-entry. That's the end of it. Full stop, nothing more to do. It belongs to the landlord. Derivative interests carved out of the lease also come to an end. So if there's subtenancies, they come to an end. The obligations of the tenant under the tenant's covenants come to an end, and so do the landlord's obligations under the lease. Claims that have accrued before re-entry are unaffected. So if the tenant has left the premises out of repair, then the landlord can pursue the tenant for that breach. If the tenant owes money, rent that has accrued due before the re-entry, the landlord can pursue the tenant for that money. So that's all pretty straightforward. The same can't be said of the effect of forfeiture by the service of possession proceedings. There are some cases which say the service of proceedings is akin to the same as physically re-entry. Well, it's not. Where proceedings for possession are issued and served, the tenancy is not finally determined against the tenant until judgment is given for possession. The given of possession, the judgment for possession, relates back to the date of service of the claim form. So the tenancy is determined then, as it were, but as from an earlier date, a bit like when one has a lease granted in 25th of March 2022 for a term starting on the 25th of December 2021. Calculate the term from the earlier date, but it only affects at law from the March quarter day. So there is an existence, as it were, until such time as the landlord succeeds or doesn't succeed in the claim for possession. And in that period between service and the judgment, the tenancy continues. It has a shadowy existence. It exists in limbo, I've heard it described. And it continues indeed until such time as the tenant is, who has made an application for relief from forfeiture, gets a decision on that. And of course, if the landlord successfully opposes, then we have the relating back to the date of service. If the application for relief succeeds, then the lease is resurrected, as it were, and continues without new lease. You might think, well, that's all very straightforward. The landlord treats the leases at an end, and it's an end, although he's got to wait for his judgment. However, it's a bit more complicated than that, because during the period of service of proceedings and a judgment, the landlord can't rely upon covenants in the lease, and therefore cannot claim an injunction, for example, to restrain breaches of the tenant's covenants or damages in respect of loss suffered after the proceedings have been served. The landlord in such circumstances might have a tortious claim against the tenant for negligence, for example, if they don't secure the premises. That's supported by the Associated Delivery and Harrison case, one of the first I was ever involved in back in 1985 in the Court of Appeal, first Court of Appeal case, where the tenant simply abandoned the premises and they were wrecked by vandals, and the landlord got into a terrible mess about the covenants, which he simply couldn't rely upon because he'd issued and served proceedings seeking to forfeit the lease. However, the tenant hasn't treated the lease as at an end. So the tenant during this twilight period can rely upon the landlord's covenants in the lease and could, for example, obtain an injunction to compel the landlord to comply with the landlord's covenants in that Peninsula Maritime case is an authority to support that proposition. So it's been held that during this twilight period, the tenant has sufficient standing to apply for a new tenancy under Part 2 of the 54 Act. And the Driscoll case, a very important case in this context, says that the tenant during this twilight period has sufficient standing to apply to what's now the upper tribunal to have covenants in the lease discharged or modified under Section 84(1) of the Landlord and Tenant Act 1925. So, as I say, in the context of issuing and serving proceedings, there is this twilight period where there's a degree of uncertainty and rather counterintuitive relationship between the landlord and the tenant. That's a consideration the landlord should have in mind when he or she decides whether to forfeit or not. Final paper, the last run in, is concerned with waiver of forfeiture. This topic throws up frequent instructions because understandably landlords are nervous that what might be a slam dunk case against the tenant might be compromised by the forfeiture being waived, and on the one hand, but on the other hand, the landlord, for example, wants a rental income. So there's a tension. What is the landlord to do? So we'll explore the concept of waiver of forfeiture in this final paper. I've used the expression 3 or 4 times now, waiver of forfeiture, but that's misleading. A landlord can't waive a forfeiture. Once the leases have been forfeited, that's the end of it. It's come to an end, subject, of course, to the tenant applying for relief from forfeiture. The more accurate description, which I've tried to use in the notes, is waiver of the right to forfeit. So the landlord can't forfeit the lease at all. No doubt I'll slip into waiver of forfeiture because everybody does. What is waiver? Well, waiver is a species of election. It arises when a person, in our situation, a landlord, has knowledge of the facts and matters which give rise in law to alternative rights, and that person acts in a manner which is consistent only with the person, the landlord in our case, having chosen to rely upon one of them. The law holds that person to the choice, even if the landlord in our case was unaware of the legal consequences of that choice. So if you've got 2 choices, A and B, and you act in accordance with B, then you'll be held to have waived A. And the Cammons Ballroom case, decision of the House of Lords, concerned Part 2 of the 1954 Act. It's not a forfeiture case, but Lord Diplock in that case spells out what waiver means, and it's a very useful exposition, and I've set it out in full in the paper. Couple of other preliminary points. Waiver of the right to forfeiture is not the same as waiver of a breach of covenant. Waiver of the right to forfeit bars the landlord's remedy of forfeiture. It doesn't preclude the landlord from pursuing other remedies, damages, injunctions, specific performance. The landlord simply decides, I don't want to break the lease, terminate prematurely, I'll sue the tenant for his or her breaches of covenant. If the landlord waives a breach of covenant, then the landlord is debarred from any remedy in relation to that breach. It's a different thing. Ingredients of waiver. 1, the landlord must have knowledge of the facts and matters that give rise to the right to exercise the right to determine the lease prematurely. The unequivocal recognition of the continuation of the lease by the landlord, and the communication of that to the tenant. I'll look at those elements or those ingredients in turn. The landlord's knowledge. The landlord must know the facts and matters that give rise, in our case, a breach of covenant on the part of the tenant, and he must or she must have knowledge of the right to make a decision to forfeit or not. We'll look at those in turn. The landlord's knowledge, what's the facts and matters? In this David Blackstone case, it says that the landlord need have only the basic facts that in law constitute a breach of covenant entitling the landlord to forfeit the lease. In this Matthew and Smallwood case, a case I do recommend, decided I think in 1900 or 1910, but very useful authority dealing with these sorts of issues. It was there said that the landlord must have knowledge of the precise facts. I speculate at the bottom of the PowerPoint slide whether what that means is that the landlord has to have precise knowledge of the basic facts, which sounds glib, and I am, but I think that's probably close to the point. It's a matter of fact and degree, again, viewed objectively, where the landlord's knowledge of the facts was such that would convey to the reasonable landlord that he or she was in a position to elect to forfeit the lease or not. The landlord's knowledge need not be personal. There's a number of authorities where the landlord has had imputed knowledge, where, for example, an employee has acquires the knowledge, and it was part of the employee's duties to convey such knowledge to the landlord. That Metropolitan Properties case involves the classic case of the caretaker in a block of flats who became aware of a subletting and didn't, as I recall, didn't convey that to the landlord. Landlord continued to accept rent, I think it was, held that the right to forfeit had been waived. It's not clear whether constructive knowledge is sufficient. By constructive knowledge, I mean where a landlord has turned a blind eye, if you will, to the facts and matters which would result in him or her having the relevant facts and matters to know that the tenant was in breach of covenant. One thing that I should have mentioned in the context of is it basic facts or precise details, is that a suspicion is not enough. If the landlord suspects the tenant's in breach, that's not sufficient knowledge. So there's authorities which I deal with in the paper where the landlord suspected that the tenant was in breach of covenant. Again, I think it was a subletting case, but the tenant assured the landlord that there had been no breach. I think it was he, still living in the premises, and the landlord was continued therefore to accept rent and otherwise act consistently with the lease continuing, and it was held that the landlord hadn't waived the right to forfeit when he then discovered that the tenant was in breach of the covenant against subletting. Landlord's knowledge of the facts, the burden of proof is on the tenant who asserts that the landlord had the knowledge. So the landlord has nothing, he doesn't have to prove that he didn't. It's for the tenant to prove that he did. The right to elect, it's an odd ingredient because it might be thought that, well, does that mean a stupid landlord? I mean that not in particularly pejorative sense, but a landlord who's unaware of the subtleties of the law of landlord and tenant, notwithstanding that they are seized of the details of the tenant's breach of covenant, will not be held to have waived the landlord the right to forfeit, whereas a more sophisticated property professional with good advisors will waive the right to forfeit. In this Court of Appeal case, it was said, not particularly sophisticated way, that common sense prevents landlords from saying that they didn't know of their right to retake possession for breach of covenant. And I think in the majority of cases that will be right. It doesn't lie in the mouth of a landlord, particularly in relation to business premises, to say that I was unaware that I could forfeit the lease and therefore I'm not restricted by my act of waiver from forfeiting. Remembering that I deal with this in the first paper, I don't think I've mentioned it thus far, that you can't forfeit a lease and prematurely bring it to an end for a breach of a tenant's covenant unless the tenancy agreement, the lease, contains a proviso for re-entry. And if a landlord is a party to a lease which contains a proviso for re-entry, undoubtedly put together by lawyers or perhaps bought from W.H. Smith in a pack, but either way, it's a document that the landlord puts his or her signature to, and it's not oppressive to hold the landlord to knowledge of what it is he or she has signed. So the right to elect is a notional, I suggest, a notional requirement. So if the landlord has all the facts that give rise to the right to forfeiture and does some unequivocal act acknowledging the continuation of the tenancy, there will be a waiver of the right to forfeit. That brings me on to the next point, that there must be an unequivocal recognition of the tenancy if waiver is to occur. Some positive act is needed. Sitting back and doing nothing is not sufficient. Pardon that sentence. So a landlord might be armed with all the facts, the precise facts that give rise to the right to forfeit, but unless and until the landlord does something that's unequivocal recognition of the tenancy, which is consistent only with the continuation of the tenancy, there'll be no forfeiture. So service of a Section 146 notice is not a sufficient positive act because that's a preliminary to forfeiting the lease. Of course, here's an important point that's often forgotten. Once the lease has been forfeited, so once there's been physical re-entry, or once the proceedings have been served, the landlord can't waive the right to forfeit because the forfeiture has already been perfected. Landlords often get nervous about accepting rent when proceedings, or accepting money when proceedings are afoot, because they can last a long time. I mentioned my case, current case, which is banging on now in 3.5 years. The answer there is immediately apply for an interim payment under Part 25 of the CPR. They always succeed because if the tenant is the tenant, as the tenant says he is, then he's got to pay the rent. If the tenant is a squatter, because the tenancy has come to an end, he's got to pay damages. And a good starting point is damages equal to the cost of the rent. So I've never done a case on behalf of a landlord where the court has refused to order the occupier/tenant to make an interim payment. Some examples of unequivocal recognition: the acceptance of rent, that waives all right to forfeit on breaches of covenant which exist up to the date of the acceptance. Acceptance of rent during the currency of a 146 notice won't waive the right to forfeiture because the right to forfeiture hasn't risen until the reasonable time specified in the 146 notice has come to an end. But again, my experience is that landlords are very nervous about accepting rent during that period. I said out there, I've got to take it a little bit more rapidly now. Acceptance of rent by an agent on behalf of the landlord is sufficient, even if the agent doesn't have instructions to do so. Payment into a bank account of the landlord can be a waiver, provided the landlord sits on the money. If he sends it back immediately and saying, I don't want this, then that doesn't count. The tenant can't force an unequivocal recognition, if you will. A landlord can't accept rent without prejudice and therefore avoid waiver on that basis. What about demand for rent? There's a decision at first instance that says a demand for rent is equivalent of accepting the rent. The point's been left open in the Court of Appeal. My view is that unless you want the rent, you wouldn't demand it. And we know that accepting the rent is a waiver, so don't demand. But of course, these cases arise where managing agents, for example, their computer says yes and just spits out a demand for rent. And the landlord or the tenant seeks to rely upon that. Waiver by pleading, touched upon already. If in the claim for possession, you claim in the alternative, or indeed as a co-remedy, enforcement of the covenants, the proceedings will amount to waiver. Reliance on the covenants, I've just dealt with that. The unequivocal act must be conveyed to the tenant by accepting the rent. If the landlord has an intercranal decision to treat the tenancy as continuing, but that's not conveyed to the tenant, then it is for nothing, because there's no act that allows the tenant to realize that the lease is to be forfeited. The effect of waiver, that depends upon whether the breaches of covenants are once and for all breaches or continuing breaches. If the breaches are once and for all, the waiver of the right to forfeit is that means that the landlord can never forfeit for that breach of covenant. So once and for all breaches include failure to pay rent, unlawful assignment or subletting, failure to carry out repairs by a given date. That's important, that by a given date, unlawful alterations. If tenant carries out alterations, the landlord, with that knowledge, therefore accepts rent from that tenant. The landlord can never forfeit on the basis of those unlawful alterations. It's game over. The position is different in respect of continuing breaches, which I'll mention in 30 seconds. Should say this, that if a breach of covenant, if a tenant's actions constitute a breach of a once and for all and a continuing, and the landlord waives the once for all, then the right to forfeit completely falls away. And the Downey and Turner case, decided in the 50s, supports that proposition. In respect of continuing breaches of covenant, the waiver of the right to forfeiture is only up to the day on which the rent is accepted. If the breach of covenant continues after that date, the landlord can rely upon that continuing breach thereafter. Continuing breach of covenants are failure to repair. Every day the premises are out of repair, there's a new breach of covenant. So if the landlord accepts rent on the March quarter day, when the premises are out of repair, the landlord can't rely upon the failure to repair up to the 25th of March, but can rely on the continuing state of disrepair thereafter. Pause there. The distinction between failure to repair and to repair by a certain date is that the certain date, once gone, is not continuing if the breach is waived. Failure to insure, failure to comply with a user covenant is a continuing breach of covenant. So every day the premises are being used unlawfully, a new cause of action arises in favor of the landlord. Repair and user are typically the most common examples of continuing breaches of covenant. The Seagull Securities Limited case supports a proposition that where rent is payable in advance, a demand for or acceptance of rent can only operate as a waiver of past and continuing breaches known to the landlord at the time of the demand. So makes the point I made a moment ago, that thereafter, if the breach is continuing, the landlord can rely upon those breaches after that period. Well, a little over time, I think, 4 minutes, according to my clock. Thank you very much for attending this afternoon. I repeat, the notes are full and will fill any gaps that you have from watching me this afternoon. I hesitate to say it, but I'm told it's true that we have a YouTube channel. And so this stellar performance, this Oscar-winning performance, will be available on YouTube. It needs parental code to put in it to keep it away from the youngsters. So if you've got nothing better to do and you want to rerun or spoil an evening for a loved one, I can be found on YouTube. Thank you very much for attending again. There's one more to come there's one more to come in the series, and that will be about this time next month. I forgot to check the date, but it's on a Thursday at 3 o'clock, and I look forward to, if not seeing you, then hearing of you then. So good afternoon.